If I'm co-parenting my child with my ex, can I move? If you're co-parenting with your ex, you must follow certain steps to move or relocate. Relocation is a move that will have a significant impact on the child's relationship with you or anyone with parenting time, decision-making responsibility, or a contact order. That could be the other parent or any grandparents. There are two types of relocations, short-distance relocations and long-distance ones. I'll start by talking about short-distance relocations. A short-distance relocation is one that doesn't have a significant impact on the parent-child relationship. For example, if you're moving to a different place in the same town. If you are moving a short distance with or without your child, you must give notice to anyone with parenting time, decision-making responsibility, or a contact order. There's no specific form to do this, but the notice must be in writing. It must include the date of the move, your new address, your new contact information. A long-distance move is one that is more likely to affect the parent-child relationship. For example, if you're moving to a different school district or a different province. In this case, you must give 60 days notice to anyone with parenting time, decision-making responsibility, or a contact order. You must use a specific form called a Notice of Relocation form, and you can find it on the Government of Canada's website. It must include the date of the move, your new address, your new contact information, and a proposal for how parenting time, decision-making responsibility, and contact will work after the move. Anyone with parenting time or decision-making responsibility can object to your relocation if you're moving with the child. They need to file an objection to relocation form with the court within 30 days of receiving your notice. That form is also on the Government of Canada's website. If you don't receive an objection within 30 days of giving notice, you can move on the date you mentioned in your notice. But if you do receive objection, you have to wait for a court order to approve the relocation. When deciding about a relocation, the judge considers the reasons for the move, the impacts on the child, if you've given correct notice, any existing court orders, and the best interests of the child. If you have safety concerns about sharing your address with your ex, for example, if there's a history of family violence, you can apply to the court to ask for an exception to the notice requirements. Thanks for joining me for this Family Law Friday. If you have any questions, you can reach out to our Legal Navigators, and their contact info is in the caption. I'll see you next Friday.